A prospective shift on the cooling-off period, a requirement for the respondent state to engage in good faith consultations. 90% of bilateral investment treaties, commonly referred to as BITs, contains a cooling-off period provision requiring both parties of an investment dispute to attempt to settle their differences amicably within a clear timeframe, before initiating arbitration or conciliation. This interval of time, during which disputing parties' efforts should aim at an amicable settlement, ranges from 2 to 12 months, depending on the applicable BIT. Arbitral tribunals have diverged on the interpretation of this provision. At times, it has been considered as an optional procedural requirement, others as a condition precedent for tribunals' jurisdiction. Much of the debate has focused on the consequences on the moving party in filing an investment arbitration, which is the investor, whenever it did not comply with this waiting period. But what if the respondent state does not comply with this provision? Function, character, and content of the cooling-off period. The cooling-off period is triggered by the notice of dispute sent by the disgruntled foreign investors to the host state. The notice opens up a predetermined window of time during which both parties will have to settle amicably the investment dispute. The rationale behind a cooling-off period is efficiency-driven, as such period allows the disputing parties to avoid altogether expensive and extensive arbitral proceedings through informal negotiations. Alternatively, in less optimistic hypotheses, it may anyway contribute to reducing the scope of the contentious issue, since parties may find a partial agreement on some of the disputed questions, and accordingly reducing the overall costs and time of the ensuing arbitration. Consequently, this period represents a valuable opportunity each party should not be deprived of because of the other party's fault, be it the investor or the respondent state. Much like a state may not revoke unilaterally its consent to arbitration, a state should not unilaterally refuse to hold consultations with the investor. After all, both arbitration and pre-arbitration negotiations are tools aimed at resolving investor-state disputes, and both tools are granted to a foreign investor by virtue of the very same international agreement. Just as an investor would not have access to a direct international arbitration with the host state if it wasn't for that international agreement, nor would it have access to direct negotiations with the government of the host state. The access to a direct arbitration with the host state should not overshadow the access to direct negotiations with the host state's government. The latter holds as much importance and uniqueness as the former. This is very much so that pre-arbitration negotiations and arbitration are always inevitably found in the exact same dispute resolution provision of every international agreement. Therefore, it would be nonsensical to hold a part of the same provision compulsory, the one on arbitration, while ignoring the other part, the one on negotiations. This entails that in principle, both parties will have to engage actively in good faith consultations before resorting to arbitration. This view is buttressed by state opinio juris as reflected by state-to-state dispute resolution provisions in international agreements, including those in BITs. The duty to engage in good faith consultations prior to arbitration to reach a friendly settlement of disputes arising under international agreements is commonly laid out in state-to-state dispute resolution provisions. These provisions make arbitration available subject to a mandatory attempt of a friendly settlement by diplomatic consultations. State-to-state dispute resolution provisions are almost identical to the investor-state multi-tiered dispute resolution clauses. In both clauses, be it diplomatic consultations in the case of state-to-state disputes, or regular consultations in the case of investor-state disputes, negotiations will take place before arbitration. Hence, the unquestioned mandatory character of pre-arbitration consultations in state-to-state disputes should also apply by analogy to investor-state disputes. Of course, every treaty has to be interpreted independently, and much will depend on how a cooling-off provision is drafted. Formulas as disputes shall be settled amicably between the parties concerned, or for the purpose of solving disputes, consultations will take place between the parties concerned, denote the mandatory character of such provision, as opposed to the use of verbs such as may or can. As a result of the terms used, a substantive obligation upon both parties to try to negotiate a friendly settlement of the dispute may clearly derive from a cooling-off provision. This obligation has a well-defined content that can effectively be fulfilled by holding fruitful consultation meetings between the disputing parties and exchanging meaningful written communications. For instance, in the United States versus France Air Services Agreement case, the USA recognized the duty under international law to engage in good faith consultations with a view towards resolving differences that arise under an international agreement and acknowledged that, in that case, such duty was met by consultations held in Paris and Washington on several occasions, as well as by the written communications which had been exchanged. This confirms that also state practice suggests the mandatory character of consultations prior to arbitration. If consultations are mandatory, by all means, each party has the substantive obligation to try to enter into negotiations effectively with the opposing party. Therefore, either party's failure to meet this obligation cannot be without consequence. Changing angle. Case law is abundant of precedents where tribunals reprimand investors for not complying with the obligations stemming from the cooling-off period. The same reprimands may be equally directed to any respondent state for failing to engage in fruitful negotiations with the investor during the cooling-off period, of course, provided that the investor has invited the state to hold such consultations. By the same reasonings adopted by many tribunals, a state that does not make a genuine effort to engage in good faith consultations during the stipulated cooling-off period should not be less reprehensible than an investor filing its request for arbitration before the end of that same period. For example, by applying to a state that ignored or refused the offer to enter into negotiations by an investor during the cooling-off period, the reasoning of the ICSID tribunal in Murphy v. Ecuador, where the investor failed to make a genuine effort in negotiating with the host state on the assumption that it would have been futile. A tribunal may get to a twofold conclusion. Firstly, in order to know that the negotiations would have been futile, the state should have at least first tried once. The content of the obligation to try to negotiate is an obligation of means, not of result. But in order to determine whether negotiations would have succeeded or not, the parties had to initiate them first. Secondly, the state's unilateral decision to completely obviate the possibility of an amicable settlement prior to the arbitration constitutes a grave non-compliance with the relevant bit. Likewise, by applying the reasoning in Kilsh v. Turkmenistan to a state not willing to enter into negotiations with the investor based on their futility, a tribunal may find that the state cannot alter the terms of the consent given. In such a hypothetical situation, a state should know that it made efforts towards complying with the obligation to negotiate, and it should bear the burden of demonstrating the probable failure of the negotiations, had they been initiated. Likewise, if these precedents are tied in with the holding in Ethelcorp v. Canada, where the tribunal assumed jurisdiction but awarded partial costs against the investor for not complying with the cooling-off period, then it's possible to get to the conclusion that the state failing to hold consultation meetings should bear the costs of the entire arbitration. Arguably, many arbitrations could have been averted, but for the state's lack of a genuine effort in engaging negotiations with the investor, who is often left with no other option than to file the arbitration in order to present its case. Thus, a state's failure to abide by the cooling-off provision may effectively make unavoidable the commencement of an arbitration. Alternatively, and more leniently, a respondent state failing to comply with pre-arbitration consultations may have to bear, if not the entire cost of an arbitration, a substantial part thereof. Arbitrators' power to allocate the costs of the proceedings, commonly found in most institutional and ad hoc rules, may award costs against the non-compliant respondent state with the cooling-off obligation. For example, Rule 28 of the ICSID arbitration rules, as well as Article 42 of the UNCITRAL arbitration rules, both recognize the power of tribunals to weigh carefully such circumstances when apportioning the costs of the arbitration. Just as it happens with a party that fails to cooperate in the arbitral proceedings by failing to enter an appearance, a tribunal may equally draw adverse inferences or make an adverse cost award in case a state fails to cooperate in pre-arbitration consultations. Tribunals have the power to take into account such circumstance when allocating the costs of the arbitration, either at the end of the arbitration in the final award, or pending the arbitration by ordering a provisional measure to the effect that the respondent state shall bear entirely any advance payments. Unfortunately, states often disregard altogether their pre-arbitration obligations. In the long run, tribunals allocating the cost against the party that ignores such obligations will incentivize also states to actually engage in fruitful negotiations before an investment arbitration. Conclusion. The cooling-off period is more than just a waiting room. It's an opportunity for both parties to hold good faith consultations in order to avert the need to resort to arbitration, or, at the very least, a chance to reduce the scope of the contentious issue by reaching a partial settlement. The investor that loses altogether this opportunity because of the host state's refusal to engage in negotiations should be held harmless. Borrowing the same arguments used to reprehend an investor for not complying with the cooling-off period, an obligation to negotiate during a stipulated period of time to resolve the dispute, a state refusing to hold any negotiations with the investor may have to bear the entire costs of an arbitration that could have been averted, but for the state's grave noncompliance with the cooling-off provision. Tribunals have the power to take into account such circumstance when allocating the costs, either during the arbitration or at the closing of the proceedings. Bottega di Bella, empowering your international rights.